I'll read the announcement if once the. Are we ready? We're good. Okay, then I'll read it. This is a public meeting, subject to public meeting law, and will be digitally recorded. Deliberation of issues will only be conducted by the police policy committee members, unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if the continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. And we will all start with introductions. My name is Scotty Downing. I'm representing non-management law enforcement.
Tanisha Barrett, also non-management law enforcement.
Sheriff Angela Brandenburg, Oregon State Sheriff's Association.
Nell Sirk, non-management law enforcement.
Mark Daniel, Oregon Association Chiefs of Police.
Alex Gardner, OSP Command Staff.
Robert Wood, public member.
Mike Frome, appearing on behalf of Chief Bob Day, Portland Police.
Casey Conning, Oregon State Police.
Samantha Costa, DPSST.
Shelby Wright, DPSST.
Erica Riddell, DPSST.
Melissa Langbacho, DPSST, case coordinator.
Phil Castle, DPSST.
And Kathy Fink, Criminal Justice Program Manager.
Bethany Copeland, DPSST.
Cindy Park, DPSST.
Jennifer Howell, DPSST.
Brian Henson, DPSST. Sam Fanny, DPSST.
In our online.
Online member Rowan, can you introduce yourself, please? Online member Rowan.
Sheriff Terry Rowan, representing Oregon State Sheriff's Association.
Online for DPSST. Jennifer Lavario.
Jennifer Lavario, DPSST.
And online we also have Kevin Lanier. You are muted.
Kevin Lanier is.
Oh, there we go. Yes, that is me. Sorry, I was having some connection issues.
That's everybody online.
Okay, has everyone had a chance to review the meetings or the minutes from our last meeting? If so, I need a motion to approve or request to modify the meeting minutes.
Conning will make a motion to approve.
Barrett also.
All right, we are voting on a motion to approve the February 22nd, 2024 meeting minutes. Chair Downing.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Sarek.
Aye.
Committee Member Cotty.
Aye.
Committee Member Daniel.
Aye.
Committee Member Frome.
Aye.
Committee Member Gardner.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Okay, first item on the agenda is administrative closures. These can be ratified by one vote, and I'll turn it over to the professional standards case manager.
Thank you. Melissa Langbacho, for the record. Mr. Chair and committee members, the department is recommending administrative closure in 6 professional standards cases and has prepared memos for your consideration on the consent agenda. The department is seeking a vote on the consent agenda or instructions to return any of the recommendations as a report for the committee's further review. Mr. Chair.
Any discussion or a motion to approve?
Barrett, for the record, I had a couple of questions. I know that staff is newer, but I just wanted to make sure, based on some of these that I read, the crimes that are listed in these that either were investigated or unfounded or case closed are more egregious than ones that we've had in the past. I just want to make sure that if we haven't heard it in a while, kind of your process of collecting the information, has everything been exhausted to include agencies, criminal reports, you name it, so that we can make sure that we have everything we possibly can on some of these? Oh, heavy questions, sorry.
Yeah, and it's hard to answer about all of them.
Yeah.
So some of them, it felt like there wasn't a need for us to pursue anything because there wasn't a completed investigation based on their separation. Some, there was no investigation at the agency, just at like the district attorney's office. And they only provided me with part of their records and information and declined to give us additional information. There was a protective order in, I think, a couple of the cases that limited our ability to obtain anything. And some of the cases had a sealing and expungement on them, which prevented us from utilizing those records because we're a party to the expungement. I do believe that we have exhausted our normal, typical channels of requesting information, but not exhausted every option, and that we don't typically reach out beyond the main parties involved for records, if that answers in any way. If there's a particular one, I'd be happy to discuss it.
The last two cases were the ones that had the crimes listed that were more egregious. Well, one case said they had 52 issues of, what did they say? The investigation included 52 issues that the agency investigated, but then there was the last two cases, one had the sexual assault in the first degree, and then the last one had the strangulation, assault, free, and criminal mistreatment. Like when somebody's not in this profession or not in this group sees those, it's like, what are we doing? So
yeah, are we
making? Is there a formality or a checkbox that you guys make sure you go through just to make sure that we're getting everything for those?
We don't have a checklist, and so for the very last case, we received information from the agency and requested court police records, but those were declined to be given to us because there wasn't a conviction in the case. We weren't entitled to them. And he was acquitted, and looking at the investigation from the agency versus the acquittal, it made it really challenging for us to understand what was, for me, which of the things he was found not guilty of, because the investigation that was done by the agency was very similar, from my understanding, to the charges that he was accused of and found not guilty of.
And Kevin Kaplan, for the record, if I may add, so in our review process, as the case coordinators in this case, it's often going to be Melissa and Jennifer, they're going to do everything they can to get the information to make an informed decision. If they can't, this is also reviewed by the manager, and then I have the final approval. And so we work with DOJ, especially when we're starting to see a few more sealed records, and for us not to even get, because the burden of proof in the court is different than it is in our administrative. So when we can get court records, we try to do that. And when they seal them, now that's just another obstacle that we don't, and DOJ has advised us on those. So usually when we're coming to the administrative closure, either it didn't meet the threshold or we've had some obstacles, and we're letting everybody know this is why we're closing it, and we've exhausted all of our efforts. But I will say that we are seeing a little bit of a pattern as far as sealed or protection orders that do limit our ability to really take a look at this. And again, if an agency is only defaulting to the criminal process and don't do a bifurcated independent one, then we have no records from them as well. And so we present to you what we have.
Sheriff Randall, for the record. So on this particular case with McCandless, if I'm saying that right. It looks like that Toledo Police Department sustained findings from their own internal investigation.
Mhm.
So is there an internal investigation that they did separately from the criminal investigation, which is a different threshold for discipline, which is preponderance of the evidence? So is that something that, because I see it as bifurcated, I see it as a criminal, there's two paths, criminal and then the internal, which is a different standard. And so would we not even look at the internal investigation? But that one, this is the same one that caused me some concern.
I would be happy to bring the case to the committee. I truly struggled with it. So, if it's a case that you would like to look at, absolutely.
I would say that we would need to do our due diligence, and if they did their own investigation, which is not sealed, and it looks like they interviewed other children who witnessed the incident, so it's a different threshold for the employer.
Okay.
If there needs to be a motion for that, I would second that because I have the same exact question written down.
Okay.
And just for clarification, Scott, down for the record, we're only talking about one of those two last cases, or
The last
are we
one,
returning two cases?
the last one in particular.
Yeah, okay.
Alex Gardner, for the record, I just have one related question. There are situations where a record is sealed generally, but the seal can be penetrated if you petition the court for an exception. And given the public interest in ensuring that we have the right people doing police work, it seems like that might be worth a poke.
And then my last inquiry, should we say, yep, we're gonna go ahead and agree with staff and administratively close these, if this person wants to try to seek outside employment at another agency? I think part of the process is they're supposed to contact DPSST right during the background check. Would this information be shared? If there was a case that was administratively closed, we can give you a synopsis, if you will, which maybe will send out red flags elsewhere.
Yeah, and the cases that we close, we're currently posting the administrative closure report online on our database. And then when agencies contact us for the background process, I think they can actually get the entire packet of information that we reviewed. And we make that available to agencies.
So it sounds like you want a motion to return at least one of these administrative.
Yes. Matthew McCandless.
Yes. You're making that motion?
She made it.
Oh, perfect, right. What was that?
I said if that was the motion.
I got you. Okay. So we are voting on a motion to return Matthew McCandless to staff to bring back to the police policy committee. So Chair Nownie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, so now we need a motion for the rest of the administrative closures, minus mechanics.
Getting for the record now, that we accept the consent agenda minus number after.
Scott, now for the record also.
We are voting
Did the
on.
vote already include the modifications as accepting, or was it just to remove the one?
I just did to remove.
Okay, thank you. Go ahead, proceed, please.
So we are voting on a motion to approve the administrative closures minus Matthew McCandless. Chair Nownie?
Aye.
Committee Member Barrett? Aye. Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, so it looks like we have 6 witnesses appearing today, so I think we may not go in exact order, depending on who's here and who's available. Deciding who we're going with.
We'll just go down in order of the list that you're given, Chair.
Okay. So the first case we're going to hear about is Caitlin Bailey. Turn it over to the professional standards.
Do you want me to wait until, Ms. Bailey comes back in to, or just go ahead and introduce the case now? While we're waiting.
As I say, I think we're waiting. Yeah. Wait.
Okay.
Say.
Routine.
Thank you, Mr. Chair. Melissa Lane Bacho for the record. The department opened a professional standards case to review the circumstances of Caitlin Bailey's separation from the Wasco County Sheriff's Office. Bailey resigned during an investigation into the lawfulness of an arrest and a use of force incident occurring during a fire at a boathouse in which a homeowner was forced to leave their property. The Wasco County Sheriff's Office continued their investigation after Bailey's resignation and sustained findings that Bailey engaged in a detention of a homeowner that constituted an arrest and was unlawful, that Bailey failed to properly document for use of force in the arrest of the homeowner and intentionally omitted information by not telling her supervisor about the incident. The department reviewed the information provided by the Wasco County Sheriff's Office and found that Bailey violated board's moral fitness standards for dishonesty by intentionally omitting the arrest of the citizen to her supervisors. The department also determined that Bailey compelled the homeowner to leave their property without lawful authority, which threatened or harmed persons, property, or the efficient operation of an agency. Bailey's use of force also threatened or harmed the homeowner by violating their constitutional rights. The department submits its findings for the committee to affirm, modify, or negate. And just for the committee to note, Officer Bailey is currently employed with the Wasco County Sheriff's Office as a dispatcher, and any action against her police certification would also impact her telecommunicator and emergency medical dispatch certifications. And Officer Bailey is here to provide verbal mitigation and submitted written information for the committee to consider. Officer Bailey, if you're ready to present, whenever you're ready.
Okay. Actually stated, I am Caitlin Bailey. First, I would like to express remorse for my actions. I did not go into that situation intending to violate anyone's rights or get into a use of force. There was no malicious intent behind that. I do accept responsibility for my actions. It was ultimately up to me to understand our policy on use of force and understanding my limits within the Fourth Amendment during fires. So that does ultimately fall on me. And so I hope that you can see that I am extremely remorseful in my actions. I've been in public safety for 8 years, and it has always been, it has always been my goal to help my community and not hurt my community. And I'm just deeply sorry that my actions did not help my community in that instance. And I hope that you can all find that I can continue to help and serve my community. But again, I do accept responsibility for my actions because ultimately it comes down to what I did. and choices that I made. There was no intent for deceit, just pure naivety in our policy, and just allowing myself to get distracted before reporting it to a sergeant. But I hope that you can all take into consideration everything and know that I would really like to keep serving my community for years to come.
You can either remain at the table, or if you feel more comfortable sitting in the chairs in the back, it's up to you.
I'll just sit here.
Okay. Turn back over to Peace Manager to.
I think we're looking for the committee to affirm, modify, or negate.
Okay. Need a motion to adopt the record as it was presented to us. Modify or negate, remove a portion.
Probably for the record, I make a motion that we adopt the staff report.
Cotting, second. Alex Gardner, for the record. I'll just say that I don't see evidence of dishonesty. I would move to strike that allegation. I think it was chaos. She made some mistakes. She was a young cop. And yeah, that's it.
Robert, for clarification, I thought we can adopt the record even if we disagree with it. And the only way we would send the record back is if we thought it was missing information or needed further clarity.
Right, you will have an opportunity yes, you're absolutely correct. Committee member you would say that I have all the information, I believe it is correct, and you're adopting it. And then Committee member Gardner, you'll have an opportunity to say whether you think there's moral fitness violations, and that's where you may say you don't see the dishonesty portion as presented. So at this time, right now, we're just looking for a motion to adopt the record so that you can continue with the case.
Yes, because I agree with Alex 100%.
Sure.
Yes. I'll restate my motion.
Okay, we had a motion and a second to adopt.
All right, I'm voting on a motion to adopt the record. Sharon Downing?
Aye.
Committee member Barrett?
Aye.
Committee member Brandenburg?
Aye.
Committee member Sarek?
Aye.
Committee member Cotting?
Aye.
Committee member Daniel?
Aye.
Committee member Fromm?
Aye.
Committee member Gardner?
Aye.
Committee member Rowan?
Aye.
And committee member Wood? Aye. Motion passed.
Okay, so we're gonna open this case for discussion. Reminder, if you remember to state your name and identify if you're saying any aggravating or mitigating factors involved in the case. There you go.
My timing has never been good. So. Alex Gardner, for the record. I don't think there's evidence of dishonesty. I think there's evidence of confusion and lack of understanding. So she screwed up. We all screw up. It's not dishonesty.
Mark Daniel, for the record. I completely agree with Member Gardner. It was a very chaotic scene, and I'm not sure how a lot of veteran people would pull it together in that circumstance. So I also agree that there's no dishonesty.
Chair Downing, I agree. Mitigating factors, obviously the chaos, even in reviewing interviews with other officers, there was confusion. There was no consensus among the officers on scene what they were allowed and not allowed to do. And so I think some people thought there was an evacuation order and some people thought there wasn't. And it's not something that I don't think police officers see very often. I don't know that I've been faced with it in 30 years, whether or not I can evacuate them or not. So, I think those are mitigating factors.
And also mitigating is that you had every level of law enforcement in the state present on this, to include another entity, which was fire. So top chaos with who's in charge of the scene, like from the top, from the bottom up, it sounded kind of chaotic. Also mitigating, I found something that Chief Deputy Scott Williams wrote, Exhibit A6 on page 7. I wish and hope that I go out with my employer speaking so highly of me on some of the things that he wrote about you as an employee. And I think that that is probably more indicative of who you are as a civil servant versus this one incident defining you. So I found that was motivating as well.
Connie, for the record, I also find her testimony today to
to be mitigated.
Sheriff Brandenburg, for the record, and your mitigating letter. It's exactly what you're saying today, so, and I think that one thing to point out too is a lot of our young cops came on during COVID, and we still are seeing effects of that, because they missed out on a lot of experience and some training, and we're still playing catch up with that too, so, glad you pointed that out in your letter.
There's no more mitigating or aggravating case manager review we discussed so far.
Sure. Melissa Langbotcher for the record. I have that, the dishonesty that the department identified was better characterized as a lack of understanding. The scene was chaotic and there was no dishonesty. Also mitigating was that there wasn't a consensus on scene with what officers were allowed to do or not do. Every level of law enforcement was on site and it was unclear who was in charge of the scene. The mitigation letters from Bailey and others that were provided were mitigating. Officer Bailey's verbal statement today was also mitigating. And she came on board during COVID, which wasn't the best circumstances for a new officer to begin a career. Mr. Chair.
Okay, so we'll open the case for discussion about whether or not there was a moral fitness violation, either dishonesty, misuse of authority, or misconduct. Discussion is open.
And Captain Cutler, for the record, this is where your opportunity is to modify and completely remove dishonesty as it has been discussed thus far.
And then just the procedure, if we remove one or all, do we do a vote on each that we remove, or do we do them? If we do more than one, do we do?
You can amend it as presented with removal of dishonesty with the second.
So, Alex Gardner, for the record, I move that we strike the dishonesty allegation.
Mark Daniel, for the record. That's fine.
Right, we are voting on a motion to remove dishonesty as a moral fitness violation. Chair Downey?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
And just to clarify, we had no discussion on the other two. No. Not have any discussion on the other two? No?
Alex Gardner, for the record, I think there's only one before us. It's the misconduct allegation, and
Oh, I got you.
so, I mean, I guess I'm looking for direction from the group. She did not have legal authority. She didn't know her authority, and so she didn't act properly. I struggle with calling that misconduct. She made a mistake. So I guess I'll wait for the group to help me understand this better.
Scotty Downing, for the record, I struggle a little bit because we also have community caretaking in the state, and I think what we get in a real gray area between what's your legal authority and what you're allowed to do under community caretaking when you normally wouldn't be able to, you normally wouldn't have Fourth Amendment rights to see someone, but you do it in the interest of public safety. And there's an ORS for that. And so that's where I've kind of struggled. Had there been a briefing and everyone was on the same page, like sometimes we do the forest fire, they're like, hey, there's a forest fire, we're gonna go out and this is what we can do and what we can't do, and there's a command post, and it seemed like that was the case here. It's been reiterated multiple times, this is a pretty chaotic environment, and so I'm struggling with misconduct as well, because I just don't see where the person is, I'm going to take this action to violate this person's rights. Does it seem like that was the intent at all?
Sure, Brandon, for the record, I think it's more, and we see this in performance. And I think for the facts that we talked about for the dishonesty, that comes over into this. And I think that it was clear that there was an intent I think her intent was to protect the person, and it comes back to that, right? So, so I think it comes back to the performance part. It comes back to the training part.
Well, Rob, for the record, speaking of intent, the report was there were people still in fire hoses during that. There were people swimming towards the fire from a pier. So I believe the intent was there, just like you said, to protect human lives and create a scene that the firefighters could protect. So I agree. I don't think there's intent for misconduct. There wasn't intent to violate someone's rights.
Mark Daniel for the record, I agree. Yep. And then also another mitigating factor on this particular piece for me was, as things had calmed down, she had an opportunity to actually pull the gentleman aside, and they had a conversation, I think a real human conversation, and there was, her admission about what she did, and the fact that she was remorseful and she was sorry about the situation. And then he actually admitted that he kind of lost his cool and kind of helped create the situation himself. So I really think that that's a mitigating factor when really looking at this incident, and she's trying to do the best thing that she possibly can for that human in that very, very bad situation.
Sheriff Rowan?
I agree with what's been said. It's almost like we would be led to believe through some conclusions that that these other witnesses or folks on scene concluded what she was thinking instead of relying more on facts. And I didn't see it. I just felt that it's more of a training rookie officer mistake kind of a situation with no intent for ill will.
For the record, I know in the past, we have said, we can agree that misconduct in black and white is here, but it's not actionable. But then if I'm maybe putting the cart before the horse, in order to keep her name as clean as possible, do we say that it's not there to keep her name clean? Do we say that it was there, but we decided that this was a training issue, this was X, Y, and Z, therefore no action? And then if that's the case, then for misuse of authority, we don't normally write that much for misuse of authority. We would just say, the department did not identify elements of misuse of authority. I want to clean that up too, for her sake. Mm-hmm. So it's kind of more of a clerical.
Actually, Captain McAlpin, for the record, those are actually really important distinctions that this committee is working on right now, because there's one thing, as you were indicating, the next step would be action or no action if you thought there was still a misconduct. What I'm hearing from the committee is that you're indicating, similar to dishonesty, that you don't even believe the elements of misconduct is there. And so you could, based on the discussion, take another motion to say, you've already done dishonesty, so you don't have to do it again, but basically the only thing that's left is misconduct. And if you wanted to take a vote to remove that as well, then that's really going to end this. And there will be no action because you've pretty much eliminated both of those. And I just want my rules person, Dr. Holland, to see if I am correct.
Yes, you are correct. And just as a process, if all of the moral fitness, if there is no finding of moral fitness, we need a path to close the case. A clean option may be a finding of no moral fitness violations, therefore a recommendation for no action. That then goes to the board, and then it's the final. That is one process option.
Alex Gardner, for the record, would that be after having a vote on moving to strike that allegation? Is that a separate finding?
I think that is your finding. So I think by saying that the committee finds no moral fitness violations, you are then effectively striking dishonesty, misconduct, and any reference to misuse, which there wasn't a finding of.
So Alex Gardner, for the record, so moved. I think errors that involve exceeding your legal authority are, I suppose, technically speaking, misconduct. But young recruits screw up all the time because it's not easy. So I move that we strike that.
Sure, Brendan, I'll second.
So we have a motion to remove misconduct.
Find no moral fitness violation.
Yeah, no more.
And take no action.
Mike Crum, for the record, before we call the vote, just maybe to help me out, do we have a definition of misconduct in the OIRs?
For the record, I was just gonna read that. It says conduct that violates criminal laws or conduct that threatens or harms persons, property, or the efficient operation of any agency or discriminatory conduct. So we're fortunate in that it doesn't tell us intentional, reckless, but it says conduct. And a lot of what we're talking about is new rookie conduct, new COVID conduct, like we can kind of.
Yeah, I mean, so Mike Crum again on the record. So, I mean, I'm from an agency that defines misconduct of any violation of rule, policy, procedure, you name it. You violate it, it's misconduct, intent is irrelevant. So I'm sensitive to the conversation that's being had at the table, but for me, the clear path is, yeah, there's probably misconduct. It resulted in a change of employment status, as well as being listed on like what tier 2 on the Brady. There's been misconduct at some point, but the next step is take no action on it later. But that's just me throwing it out there for the group. But I think we now are supposed to be voting on Major Gardner's motion.
I mean, for further clarification, is that path available where technically the conduct occurred, but then the subsequent recommendation is no action?
Yes, that would be your next, if there was an agreement that there was a moral fitness violation, then the next thing you'll be discussing is to take action or no action. So that would be the next step.
So we have a motion and a second to remove misconduct. Correct? We do.
Yes. Okay. So we'll take the vote.
We should vote on it.
All right, we are voting on a motion to remove misconduct as a moral fitness violation. Chair Nowling?
Aye.
Committee Member Barrett?
Nay.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Nay.
Committee Member Daniel?
No. Nay.
Committee Member Fromm?
Nay.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
Committee Member Wood?
Nay.
It's tied. Split down the middle.
Okay, I believe that requires further discussion on that, yeah.
Probably for the record, I think we're getting into a sticky situation if we're redefining OER. Love your definition. What I wish, and we're working in the moral fitness work group, is we have the ability to affirm as a violation with 0 revocation period. But we don't have that right now. So I'm hearing that we have the option to agree there was misconduct, but then the possibility of taking no action. Okay, that's why I voted against this.
So Alex Gardner, for the record, what I struggle with is that normally screw-ups of this level wouldn't come to this group. Young recruits, new recruits make all kinds of stupid decisions that are violations of authority, and it's a lack of experience and training. And so arguments on the other side of this are very good. I understand them. I struggle with having blotch on her record that would not have been merited in 99 out of 100 other cases of similar, confusion.
Scotty Downing, for the record, she called for cover. They had a hard time even figuring out where she was because of the chaos. There's presumably many supervisors on this scene. This is a thing where a young officer is taking action, a more senior officer says, we don't do this because of whatever, and you correct the situation. She didn't take this person to jail, she didn't continue on. Once the situation was realized, like, hey, we don't probably have the legal authority to do this, it was stopped. I agree with Alex Gardner. This is, yes, her initial judgment to say, hey, I'm going to take you into custody and remove you from this dangerous situation. I would still debate whether or not she has that authority under community caretaking. But it was determined that she didn't have that authority, but then it was stopped once someone who had more knowledge or time had come where it was less chaos in a different environment. They got back together. So I agree with Alex Gardner that I just have a hard time with misconduct on this.
Fair, for the record, I needed to hear that last comment from Gardner about these wouldn't normally have been brought up to here, but where it's triggered because she resigned. In lieu of, if she would have gone through the investigation, maybe survived, this would never have been here. So we wouldn't even have heard it.
So, Robert, for the record, it is before us. We can't do that. And the concern about blemishing the record is already blemished because if someone's doing due diligence in a background check, they're going to go to a prior employer and find the exact same thing out. So is it going to make it worse that we have found a moral fitness violation and did not take any action? Would that change a future employer's perception of that came out of the PPC versus what came out of the prior employer during a background check? There's always something.
Not a good record. I just struggle with removing it altogether because the actions did occur. I think all the mitigation that we spoke about earlier is what's going to then be the subsequent conversation about action or no action. But for us to have the record that we've accepted and then find all the reasons why we're going to go a different direction, I struggle with it. I believe it occurred, and then I think I'm going to weigh in on the mitigation in a second.
Okay. Do we want to try to vote again? To have more discussion? Wait, I'm sorry. Sheriff Rowan?
I don't have anything further. I can't figure out how to unraise my hand.
I'm going to keep calling on you then. Perfect.
Chair, would you like a roll call or you want further discussion?
If there's no further discussion, will we just roll call again? Is that how we do it?
If you're voting on the same, are you calling the same motion, or is it a new motion?
Okay, okay.
Okay, Jennifer Howell for the record. So because of the conversations that have been happening, just referring back to the definition in administrative rule for misconduct for the purposes of a moral fitness violation that warrants consideration of certification. Reading that portion again as it had been previously read, misconduct includes conduct that violates criminal laws, conduct that threatens or harms persons, property, or the efficient operations of any agency, or discriminatory conduct. So if the committee finds that the facts of the case meet that definition of misconduct, you can say, you can move forward that misconduct occurred as moral fitness violation for certification, and then you would go on to your next action, which would be whether to take action against the certification or recommend no action.
Alex Gardner, for the record, I'll just ask the group to consider one piece here, and that is, did her action threaten or harm persons, property, or the efficient operations of an agency? That's part of the definition of misconduct. And I don't see how she threatened or harmed a person's property or the efficient operations of the agency. It was chaos. She was trying to do something to protect somebody, and I can't identify any harm.
Right, Mike Frum for the record, since I think I kicked this mess going. I'm willing to listen to that definition of misconduct and decide that what we're really talking about here is probably not misconduct. I think, you know, she's here today and she's very sincere. And I really hope you have a long career in law enforcement. I hope maybe someday someone gives you another shot at being a police officer. I mean, this is not designed to do any of that whatsoever. But maybe, I guess, where I'm looking at this now is that her decision to maybe detain or arrest this person really was more of a misuse of authority, which we had not even put before us, and not so much a violation of a criminal law, a harm to any individual or anything that falls into this misconduct. So if you would like to recall the roll, I think the vote will be different.
Let's do that then.
So for clarity of record, you're recalling the roll on the motion that there is no finding of misconduct and therefore no action? That was the motion in the second?
The motion was to remove misconduct from as a finding. That was what we voted on.
And close, right, and to close.
Yeah.
Both of those.
Can you say it out loud, Erica, what the motion is again?
I don't even. It was to remove misconduct as a moral fitness violation, and I believe you said you wanted to close it as well, but I don't think anybody had said that in the motion.
So
I can add that to the second.
So Erica, we fixed that. I've moved and Sheriff second.
Perfect. We are voting on a motion to remove misconduct as a moral fitness violation and take no action. Chair Nowman.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Sarek.
Aye.
Committee Member Cotting.
Aye.
Committee Member Daniel.
Aye.
Committee Member Fromm.
Aye.
Committee Member Gardner.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Wood.
Nay.
Motion passed.
Thank you. Yeah. I will follow up with something else.
Thank you.
So number
Yes. Next case is Quinn Lindley.
Sweat my nose.
You're safe here.
You're safe here. 2, 3, okay.
Three.
Yeah.
That's four.
Okay. All the cases for you and LG.
So this is the great one.
Yeah, and they would be too beautiful for the middle of the week.
That's a lot. Very good. Sounds like you're saying it's
It's changed. I didn't know that. Well, it does tend to probably because the GAs tend to draw. The agencies know. But some of these things are just crazy.
It was fun.
Yes.
Okay, if you want to go ahead and introduce the next case.
Thank you. Melissa Lane Botcher for the record. The department opened a professional standards case to review the circumstances of Quinn Lindley's termination from probationary employment with the Monmouth Police Department. Lindley's termination came after an attorney submitted a complaint alleging that he was deliberately dishonest or misleading in his reporting of an incident and acted with an improper bias. The Monmouth Police Department did not complete an investigation into the matter, but did review the complaint, which included recordings of a judicial finding that Lindley was not credible. As part of his termination, the Monmouth Police Department provided Lindley with the opportunity to respond to the allegations and judicial findings, and the department reviewed the information that was related to his termination and found that Lindley exhibited an intentional reckless disregard for the truth in his reporting and testimony in a criminal trial, and that Lindley's improper judicial testimony, poor investigation, and reckless disregard for the truth harm persons and the efficient operations of agencies. The department submits its findings for the committee to affirm, modify, or negate, and Officer Lindley is here to provide verbal mitigation and has submitted written information for the committee to consider. Officer Lindley, if you're ready, we have a timer that will begin when you start.
Perfect, thank you so much. Good morning, my name is Quinn Lindley, and I'm gonna work really hard to stick to that 5 minutes this morning. So I would like to start out by saying thank you for the opportunity to speak to you today and to provide some clarification on these events. First and foremost, I would like to impress upon the committee that at no time, working in any capacity as a peace officer, writing any investigative report, or testifying in the courts, did I try to conceal or purposefully omit any details in my investigations. When I was hired as a law enforcement officer, I knew that I was hired to swear an oath, and I held to that steadfastly. Honesty and truthfulness are deeply ingrained in me, and my whole life reflects this. I do not believe my conduct rises to the level of further disciplinary action or adverse action against my certification. I acknowledge I made mistakes as a new officer, and I certainly regret the mistakes I made and how they may have reflected on the state of Oregon, my chosen profession, my colleagues, and myself. This incident has been hanging over my head for 5 years. It has stifled my career plans and dream, which has been nothing short of devastating. The letter from Tim Park, who was the defense attorney at the time, calling in to question my honesty, deeply affected me more than anyone could ever know, and I regret that I did not get the chance to defend myself in any investigation. When it occurred, I was a young man and passionate about police work and eager to dive in. As a Monmouth police officer, I also knew I was held to a higher standard in that position, as it was the town I grew up in and was raised in. I made a mistake, and I own that mistake, as I was only 24 years old during this incident. I am now 31 years old, and since 2019, I've already grown immensely both personally and professionally, as you will see. I have also taken my experience as a learning tool to better my skills and judgment. With that in mind, I would just like to offer a few following mitigation points today. I believe the issue was framed incorrectly, and that the real issue isn't one of dishonesty, but rather is an issue of lack of training, inexperience, and a lack of supervision within my department and Polk County District Attorney's Office. I was not prepared in advance of trial by the police department or the DA's office, and certainly not the Deputy District Attorney who handled the case. This trial was my very first trial testifying experience. And when I wrote the initial report, the offender was arrested for several misdemeanor criminal arrest charges. That included menacing, trespass, and assault 4. When I arrived at the Polk County Courthouse only 1 hour prior to the trial, the Deputy District Attorney assigned, her name was Sarah Shepard, indicated she had increased the assault 4 to a felony level assault 2 without notifying me. Prior to the trial in November 2018, I emailed Shepard several times as I was a brand new officer and had never attended the trial or provided testimony, yet she only agreed to meet with me 1 hour prior to the trial. So prior to this, Shepard and I had not reviewed the report and body camera video, nor had she informed me that she'd received communication from Defense Attorney Tim Park telling her he was going to have a field day with me as a new officer in court. This lack of preparation and not reviewing the body camera footage with Shepard contributed to my first trial experience, resulting in a mistrial. After my experience, I asked my chief, Daryl Talon, for additional training, which I later completed related to courtroom testimony. I admit I did not review the body camera footage for this investigation when I wrote my report. This can be attributed to me still being on probation, being told by other officers that it was discretionary to review camera footage when writing a report, and also because it was my first experience juggling submitting multiple reports while also responding to calls, oftentimes as the only officer on duty for the entire community. It's also important to note that during my field training, the MPD policy did not require officers to refer to the body camera footage while writing reports, and it was discretionary. And this is simply what I was taught. Instead, I made the mistake of only reviewing my handwritten notes, as well as being served by my memory of statements made by parties on the scene. Because of this, I misattributed quotes between two parties on scene, as I was clearly a new officer, disorganized, and still learning. After my dismissal, MPD changed their policies on viewing the body camera footage while writing the report. I think the purpose of a lengthy probationary period for police officers is to allow adequate time to learn and adapt in the field, and to be critiqued and learn from feedback and mistakes. I would also like to point out that after writing my report in September 2018, I continued to learn and grow as a police officer for almost another entire year, and I passed the rest of my field training with excellent marks. At no time was there intent or reckless disregard for the truth of my reporting or at trial when testifying. I was attempting to respond to the questions posed based off of my inaccurate report at that time, which I did not know, and I didn't understand the subtle legal nuances that my testimony would cause a mistrial. The judge of the trial himself, even Judge Norm Hill, indicated he didn't believe that I knew my legal ramifications or statements in court. I just have a bit here more. Defense Attorney Park took poor report writing mistakes of a rookie probationary officer.
Sorry to interrupt you, have to stop at 5 minutes.
Okay.
It's the same for everyone, thank you. So you're welcome to sit at the table, or if you're more comfortable moving to the back, it's totally up to you.
Okay, thank you.
Okay. Okay. We need to have a motion to adopt the record. Before that, I have a question. There was no internal investigation done, including our back vote.
Correct.
Making the assumption of no internal investigation.
Correct, yes.
Okay, thank you. So a motion to adopt the record, or return it, modify it, maybe?
Derek, for the record, I motion to adopt it.
Second.
We are voting on a motion to adopt the record. Chair Nownie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Okay, we'll open the case for discussion, aggravating and mitigating factors.
Well, with the record, I'll offer some mitigating factors is his testimony today, his written testimony. I found it interesting watching the body cam video of him taking notes and how haphazard they were, which is a training thing, maybe an experience thing, and I can see how he could confused when he's writing the report up. I have some aggravating circumstances on that as well, but I'll do that.
Thank you. Anyone else? Anything else aggravating or mitigating? Discuss? Got an amateur, and I would say mitigating is his own testimony. It's his first trial. It's adversarial nature, and there are things you can say during a trial which probably there's not a ton of training on that can cause mistrial. So that's happening. I think that would be a mitigating factor, just a sheer lack of experience being a new officer in a trial situation. And you rely heavily on the district attorney to prep you of those things that we have to stay away from, to avoid mistrial.
Mark Daniel for the record, I'm not sure that this is really a mitigating circumstance, but, there's just no more information, nothing from the agency. I certainly would have liked to have heard a little bit more, or anything from Monmouth Police Department as to what they were really thinking about this, He comes before us today to talk about the fact that, his training was what his training was, and there was lack of supervision, and I can't help think that that is a significant possibility, especially getting him ready to go to trial and testify, and really even know how to put that body cam video, if you will, and the report together. And the district attorney's office, I also believe, didn't do him any favors by refusing to meet with him or preparing him better for trial.
Scott Hamler, I think probably the reason we're not having much conversation is because everyone's probably thinking the same thing. We only have information from the courts, which is what is allowed in court is obviously a lot less usually than what we would be privy to had his department done an investigation, and he would have been subject to a full interview where they could have really asked a lot of questions that I think at least I have for sure. So I'm just really struggling with the limited amount of information we have in this case.
Alex Gardner for the record. I'm just observing that the standard required before somebody is called a liar seems to be declining. It seems to be easier and easier to call somebody a liar as opposed to being incorrect, mistaken. His notes were terrible. His FTO should have told him that you better watch your body cam for writing a report because the exposure is much higher than it used to be, and you will be held to that body cam. I don't know whether the FTO did that or not. He's saying that he didn't get that direction. I just find it very troubling because people routinely testify to things that are not correct because they're mistaken. They misremember, they have lousy notes. For me, before I call somebody a liar, I need to know that they were lying. I don't like that.
Probably for the record, I actually agree with that. During the testimony, which I listened to, he truthfully answered every question asked by defense attorney, even though it conflicted with his written report, which conflicted with the body cam. So that's an additional mitigating factor to question being a liar, as you bring up.
Any other aggravating or mitigating? Do you want to review them? Thank you.
I'll sign back with the record. For mitigating, I have that his statement today and written testimony were mitigating. The way that Mr. Lindley was writing his notes while interviewing people was done in a haphazard manner, and it could be seen how it would lead to inaccuracies in reporting. It was his first trial, and trials are adversarial by nature. He had a lack of experience and was relying on the DA to avoid mistrial. There was nothing from the agency as to what they were thinking about the allegations. There was a lack of training on testifying and report writing. The standards for identifying someone a liar are lower now than before because of body camera. His testimony in the trial was truthful, even though it conflicted with his reports. Mr. Chair.
Thank you. Okay, so we now need to open discussion of whether there is a moral fitness violation. We can affirm, modify, or negate the moral fitness violations found in the report. Discuss that.
Would you like us to take it one at a time? Go over the dishonesty and misconduct?
Do whatever you like, I think it's, as long as you're talking, yes. Right, so, I'm just following the new rules.
Well, Robert, I'd like to suggest before a motion is made that we consider striking dishonesty from the record.
Almost second it.
Yeah, I guess it was a motion then.
Or can I discuss it? Okay, we're voting on a motion to remove dishonesty as one of the moral fitness violations. Chair Downing?
Aye.
Committee Member Barrett? Aye. Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, so we're left with misconduct. So open the discussion for misconduct.
Okay, well, I'll wait for the record, I'll get this going. I think we're starting with the same thing we started with in the prior case, that, with the definition that Jennifer Hall read, I think you have misconduct, because it did harm the defendant. But that harm was then rectified with a mistrial. Was it intentional? That's not part of the definition.
Alex Carter, for the record. Reckless disregard for the truth is I can't make sense of that in this context. He was incorrect when he testified, but we don't have sufficient evidence to conclude that that was intentional on his part. So I don't see the allegation.
I think further discussion in our prior vote on dishonesty, if I kind of look at that through the misconduct lens now, we're really left with the core investigation. And we've already spoken about his lack of proper notes, subsequent police report, which then led to the inaccurate testimony. But I don't see that necessarily as misconduct. I see it as training.
Probably not for the record, I agree that to me that's a performance issue. When you get rid of the truthfulness aspect of it, it's a performance issue. And the way you get really good at testifying in court and making sure you have proper notes is to go through court a few times and understand what the expectation is and understand what can happen if you're not prepared. So I think it's a problem which corrects itself for a lot of officers who are new as they go through court. And a lot of times it's in traffic court, not in a felony case. So,
Okay, for the record, I just want to agree with Scott.
thank you. So do we want to make a motion on this other on misconduct?
And if you remove the misconduct, Chair, then you would also want to say, and that will close this case out. I think it's a terminology that Jennifer because this will be the last one to be reviewed.
Right, so basically we are moving it forward to the board as there was no more moral fitness final, no moral fitness finding, therefore no action. Right. Or no action taken.
Scott Young, for the record, I'll make a motion to remove misconduct and therefore have no further action.
Mark Daniel, for the record, I'll second.
All right, we're voting on a motion to remove misconduct as a moral fitness violation and take no action. Chair Nownie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you very much.
Thank you all.
5 minute break. Then we'll go to 5 minute break.
And then it'll be Sean Fulton, will be the next one when they come back.
Okay.
Good work.
Nice to go.
Good work.
Thanks.
I like that. I'm not even sure where we're at right now.
I know, I was like,
It's good to see.
I was like, wait, speak up, you gotta know. Okay.
Okay, the next case on the agenda is Sterling Hall. Book 3, tab 1.
It didn't go well. Thank you, Mr. Chair. Melissa Lake Botcher for the record. The department opened a professional standards case to review the circumstances of Sterling Hall's separation from the Pendleton Police Department. Hall was terminated from employment following an investigation into a domestic violence incident in which Hall admitted to slapping his former domestic partner. The department reviewed the records related to Hall's termination and identified a moral fitness violation that Hall threatened or harmed another person with his conduct by pushing and slapping his domestic partner during a verbal altercation. The department submits its findings for the committee to affirm, modify, or negate. Officer Hall is here to provide verbal mitigation and submitted written information for the committee to consider. Officer Hall, if you're ready, you may begin your statement to the committee.
Okay. First, I'd like to thank you for being here. It's been a long 2 years waiting to get to this point. On the other hand of that, I'm sorry that you're here. It's unfortunate that I have to be here in front of you rather than working. I would like to say that my actions on October 9th, 2021 are not indicative of how I was raised. I was raised much like most of you were likely raised. I grew up in a trooper household. And integrity and justice and I guess you could say good old American values was what we were expected to become and behave as children growing up and young adults and men. I can't take back what happened that morning. I wish that I could, but I've spent the last 2 years, 2.5 years really since the incident, regretting that day, regretting that morning. And if I could say something to my significant other, the woman that I loved at that moment, I wish we could do things different. However, you can't take back what's already happened. So I'm here, I suppose, pleading to you to show empathy, take my statement of remorse and regret to heart. I know that these last few years have been very humbling for me. I found myself without a job, lost my home as a result of that, and found myself working a dead-end job, security. However, I learned a lot from that job. I learned a lot about people, and I put the skills and things that I learned as a police officer to use in building relationships with those people, and I'm thankful for that opportunity. I've also been a member of the National Guard for the last 9 years, and through those connections, I gained a job at Reese Training Center. That only increased my abilities to take extreme ownership of my actions and work with the community as a whole, which is something that gives me great pride. I know that nobody can condone the actions that I took. However, I hope that you can see that that's not who I am. Those actions don't represent the type of man or person that I am and have further become. That's my statement. Thank you.
Okay, we need a motion to adopt the record, permit, modify it, mediate it.
Representative, I make a motion to adopt the record.
Scotty Downing, I'll second.
Probably with the discussion item on page, this is exhibit A4, page 1 of 2. Mr. Hall points out there's a possible discrepancy in the record. Has staff had a chance to look into that?
And remember, we're just for clarity, there's a motion to adopt the record, and seconded, so you're clarifying something before we take a vote on that? Just want to make sure, or did you already go into the case itself?
No, I'm not going into the case, I'm going into the
Thank you.
record itself.
Okay.
So I'm questioning, there could be an error in the record, and if that's the case, I think we should, I'm asking staff, was that error that was pointed out by Mr. Hall looked into? And has the record been corrected?
Moment.
He states that the quote is by the wrong person. Yeah, so just to go off of that one, so on the very first page of the memo at the very bottom, the quote says, she detailed that during their argument, Hall walked away from where they were talking and stated, "Are you serious? Like you're not even gonna fight for me?" I believe that quote is attributed to her, not to Hall.
I haven't made any changes to the report based on his mitigating statement.
Is his concern in conflict with the evidence you would have? Or is he correct in that?
I believe he's correct.
So, we never voted on the ones who affirmed it, but it sounds like we have some information where someone wants to modify it. Do we have to do a vote on the first one and vote no essentially to affirm it and then have a vote to modify it? Is that how that would go?
I think so, yeah.
Okay. Okay, or we can withdraw. Do you want to make, or does someone want to make a motion to withdraw there, or are you good?
Wasn't me.
Wasn't me. No, who made it first?
I did.
Yes.
I'll withdraw.
Okay, we can.
So then we want to modify it?
Sure, I'll make a motion to modify the staff report to change that quote on page 1, 2 to the, to correct who actually made the quote.
You want to second it?
I'll second it, and I don't know if it's useful or not, but I think if we go to the second page in the staff report at the very top, if we just insert the word she between and stated. So it then says, then he walked away from where they were talking and she stated, that I think will fix it.
Right, well, so we are voting on a motion to modify the record as discussed. Chair Nownie?
Aye.
Committee Member Barrett? Aye. Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, with it being modified, we need to open for discussion, aggravating or mitigating factors.
Finding for the record, mitigating is his written response. He does admit to making the wrong choice in that moment, and he does appear to have remorse for his actions.
Sharon Elling, I the same mitigation, the fact that he never denied it was, seems to be a bit honest about it from the get-go and continues to take responsibility for it.
Mark Daniel for the record, I agree with both of you. He's never attempted, apparently, to hide what he did that night.
Any other discussion on aggravating and mitigating factors on this case? None. Review.
Yes, Melissa Lane Botcher for the record. For mitigating, I have that Officer Hall's written mitigation appears remorseful. He never denied what he did and accepts responsibility, and he never attempted to deny his actions. Mr. Chair.
Okay, we can open the discussion on whether or not there is a moral fitness violation. The department found misconduct as a violation. We can open up the discussion.
Alex Gardner for the record, I don't think there's any doubt that there was misconduct. You can't strike your spouse or your significant other. And I struggled with this one because he does need to sort of set out the facts, the circumstances, but it had the flavor of justification, and so I'll just say that misconduct is clear.
Scotty Young, for the record, I agree that I agree with the department's finding misconduct. As a police officer, especially, it's not only is it illegal, it's a mandatory arrest in the state. You just can't put hands on a domestic partner or family member, so it's pretty cut and dry to me that it is a misconduct violation. Any other discussion on that? Okay. We need a motion to affirm, modify, or negate the moral fitness violation, which was the only one that's been discussed so far in misconduct.
Alex Gardner for the record, I move that we affirm it.
Mark Daniel for the record, second.
All right, we are voting on a motion to affirm the moral fitness violation as presented. Sharon Downey.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Sarek.
Aye.
Committee Member Cotton.
Aye.
Committee Member Daniel.
Aye.
Committee Member Fromm.
Aye.
Committee Member Gardner.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Next, we're going to have a motion to take action or no action, and I wanted to ask a clarifying question first. If we do take action, and what's the date we're talking about when it would be effective if we end up?
It would
Did they put it in there?
April
I was gonna say, I thought I read it.
Yeah, we're gonna put it in the report somewhere
Yeah,
there.
so, April 20, okay, thank you. April 26, 2022. So we need a motion to take action or no action.
Jared, another qualifying question, if we decided to take action, what is the minimum? Is it 0 or is it 3? What our numbers are, 1.
3.
Sure, Brandenburg,
Move that we take action.
Mike Fromm, second.
Voting on a motion to take action, Chair Nownie.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Sarek.
Aye.
Committee Member Cotting.
Aye.
Committee Member Daniel.
Aye.
Committee Member Fromm.
Aye.
Committee Member Gardner.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Wood. Motion passed.
Okay, so now we need to, now that we take it, vote to take action, we need to decide the ineligibility period for misconduct or misuse of authority. It's 3 to 10 years. Which is what we're looking at here. So from 3 years is the minimum from April, was it 2022? Until the minimum we could do it would be April 2025. And then the max on this would be 10 years. Scotty Downing, for the record, I would make a motion that we impose 3 years, which would be the minimum on this, just taking into account the mitigating factors and lack of other information that shows this is a pattern or anything like that. So,
For the record, I second that motion.
All right, we are voting on a motion for a 3-year ineligibility period. Chair Nownie.
aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Sarek.
Aye.
Committee Member Cotting.
Aye.
Committee Member Daniel.
Aye.
Committee Member Fromm.
Aye.
Committee Member Gardner.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Thank you.
Thank you.
Oh, not yet, or one more? Is the UI person here? What do you do?
Maybe it doesn't matter, they walked up their visitor badges.
The
Ross,
sticky
bye.
ones? No, the sticky ones. The officers ones.
Okay. Trying to get Rob with you about.
To your credit, you did not have to find. He
Oh.
is out there, yeah.
It's like, okay.
He and his attorney.
We do have, Corningham, out there right now.
But not, Constantine?
We'll go out and check, but so far he wasn't out here.
That's last great.
Did you
stay? Okay, when is that?
Yeah, we have to do first and first and then,
Yeah.
then mine and then, but. Because there's a couple of ones, one chapter, this one.
That's good. Where are you bringing?
Carney? Yeah, we'll do that. Right now, Carney, this is.
His attorney too.
I'm dead.
Carney, tell me for it.
Okay.
Okay.
Yes.
You just bring in as you say, come in and I will go.
This is the one that's good.
Okay. This is good. Just keep on like this. I can be right.
Tanisha is a great professional.
That's right. It's all right. That's just all right.
I've learned how to phrase things because that has come up to visit you 5 years ago.
And we know.
I just run out of directions again.
So again, you make me a chauffeur.
Hey! Wow!
I was like, do I not?
You gotta get that too.
She's coming up for caffeine.
I got something in the can.
And over there. Sensor, yeah.
Keep watching.
I hurt you. Yes, yes.
Scott, in your case.
Book two, tab two, Carnahan.
Thank you, Mr. Chair. Good morning, Mr. Chair and committee members. The department opened a professional standards case to review the circumstances of Sean Carnahan's separation from the Columbia County Sheriff's Office, where he was working as a reserve deputy while also employed with the Vernonia Police Department as a police officer. Carnahan's separation from the Columbia County Sheriff's Office followed a complaint from deputies from Clatsop County Jail who were participating in a job shadow in Columbia County. The complaint included concerns about horseplay at the jail, and according to the Columbia County Sheriff's Office, when asked, Carnahan denied attempting to give another deputy a wedgie. The Columbia County Sheriff's Office found discrepancies between the denial and video from the room which showed Carnahan attempting to give another deputy a wedgie, and they began an internal investigation into the complaint. During the investigation by the Columbia County Sheriff's Office, 2 deputies shared additional statements they recalled Carnahan stating, one of which Carnahan was discussing his work as a police officer and reportedly said that instead of bringing the cute girl to jail, to offer her backseat bail. The committee previously returned the case to the department to request additional information from the Vernonia Police Department. And in reviewing the information obtained, the department found that Carnahan was untruthful when he denied attempting to give another officer a wedgie. Carnahan was deceptive when he denied remembering the previous conversation with the lieutenant. The department also found that Carnahan's conduct at the Columbia County Sheriff's Office threatened or harmed the efficient operation of agencies. His horseplay and unprofessionalism presented scenarios where the Columbia County staff were distracted from efficiently doing their jobs because of his conduct and unethical statements he reportedly made, which reflected negatively upon the profession. The department submits its findings to the committee to affirm, modify, or negate. And Officer Carnahan is here to provide verbal mitigation and has submitted written information for the committee to consider. Officer Carnahan, if you're ready, you can begin your statement to the committee.
Okay. Thank you, everybody, for giving me a second chance to come in and talk to you. My name is Sean Carnahan. I'm with the Vernonia Police Department. I have never denied the horseplay. Okay. From day one, I admitted it. Everybody did it at that facility, to include command staff. I regret not putting a stop to it. Looking back now, it was probably very poor judgment in front of to do that and not set the good example that I did, or not set a good example. As far as the statements go that the Clatsop County guys made, those are allegations. Okay, I never made those statements, and they were never investigated. Okay, they weren't part of the investigation initially from Captain McFarland to Lieutenant Salee. They're not even in Salee's report other than when he interviewed the Clatsop County guys. If you review Lieutenant Salee's report, everybody admits to horseplay in there, or in his report. The inmates were never identified and interviewed. The staff members that were in the staff room were never identified and interviewed. Please take these allegations as what they are, as allegations. I don't know the motive behind them from the Clatsop County guys. You know, and I'm sorry that they had to experience, you know, us horseplaying. However, in the control room, Hutton, Control Tech Hutton, Scott Hutton, stated that every time that we're up there and he can't pay attention because everybody is either talking, being louder, or boisterous or something. You have to read his statement that he gave Lieutenant Salee. But we were all guilty of it. But I am owning my part of it. If I could go back and change it, I would, but I can't. So I just have to accept my actions. Thank you.
And you can either remain at the table, or if you want to sit against the wall, or next to your attorney, or whatever you'd like. Okay, we need a motion to adopt the record, and just a reminder, this was sent back to get additional information for the record. I don't know, do we want to address what additional information was received or not received?
I believe it was added as an additional exhibit, just the email chain, which followed up on whether or not they conducted an investigation or intended.
Is everyone clear on that, or on that part of it? I think we had sent back to find out if Vernonia was doing an investigation, and they had not, so. We need a motion to adopt the record, modify it, or repeat it.
For the record, I think I was one of the ones that wanted to send that back to see what Vernonia was gonna do, but knowing that they did not open an investigation and there's nothing to get, then I say that we move forward with adopting the record.
It's coming in a second.
Right, we are voting on a motion to adopt the record. Chair Nowman?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, time for discussion on aggravating or mitigating factors in this case. Maybe I have a clarifying question. Is our conversation last time, assume it's part of the record, or? No, we had a pretty robust conversation last time, and then we came to a decision that we needed more information, so is our conversation last time part of our official record, or is this a whole new start?
I would defer to Jennifer Howell on that.
We're all looking at you.
Personally, did not record the discussion, from the last time in the cover memo. So we would have to pull that from the minutes to review it.
Okay. And the reason I asked, maybe more just for the committee members, if they think, well, I've already covered this, that we do have to cover it.
I think for the sake of today, we should cover everything fresh.
Okay, thank you, appreciate it. With that in mind, aggravating, mitigating factors.
Well, for the record, this might not be super helpful, but I mean, an aggravating factor for me is that he is a supervisor, right? And he recognizes that he probably should have stopped something at a certain time. But then I'll give it to him as mitigating that he is in front of us. He is, attempting to take responsibility for his actions. So there, aggravation and mitigation at the same time. Rob Wood, for the record, aggravating is the frequency and repetitiveness of what I would call sophomore behavior. So it wasn't one instance. Also aggravating is if you're in a group situation, that does not make things right.
Alex Gardner, for the record, I agree with that. At the same time, I think it's somewhat mitigating that command staff tolerated this. It's so pervasive, they had to have known that this was going on. There could be pictures that were posted on doors and that kind of thing. They allowed that environment. It should have been corrected.
Fair, for the record, I would second that. That's a culture that's been allowed to foster and grow, and it's gonna take some time to work that way out.
Other discussion? Okay, did you want to review the?
Yes, Melissa Lane Botcher for the record. For aggravating, I have noted that Officer Carnahan is a supervisor and recognized that his conduct was inappropriate. The conduct was sophomoric behavior, and just because it was in a group setting doesn't make it right. For mitigating, I have noted that he's here and is attempting to take responsibility for his actions. And somewhat mitigating, the command staff would have known about the conduct and behavior at the jail. The culture change will take time to grow away from the behaviors that we've identified, Mr. Chair.
Thank you. Okay, we'll open up the case for discussion of whether or not we agree there is moral fitness violations. The department has identified dishonesty and misconduct in the report. And Scott and Anna, for the record, I'll start with the dishonesty. It's again, we're kind of right there. We're talking about a wedgie, and did you do it or not, or did you try to do it? It's a big label to put on someone that says you're dishonest to the career field. It seems like I think someone called it sophomoric type deal. I think it's I have a hard time saying you're a dishonest person.
Okay, I'm gonna question you, Robert, for the record. So are you saying that the action, because I think we're talking about dishonesty here, there's an allegation of denying that when others affirmed that occurred?
Well, they had a video that says maybe he attempted it, or he was gonna try to do it.
Mike Crum, for the record, I mean, I think at one point we actually have someone being interviewed that kind of gave the old, like, I never pulled my sister's hair, I just held and she did the pulling. I mean, we've got one saying like, well, he had a hold of my underwear, but I was the one pulling away from him. So I think this is going to sound really silly. The whole thing for dishonesty in this one, this is a big mess of people doing a whole lot of dumb stuff. And I'm not personally compelled to believe that we're into the level of attempting to really lie about things that would make me feel comfortable at finding dishonesty in this.
Sheriff Brandenburg, for the record, I flagged that too. It was the attempted and whose definition and what was the action, and it's kind of a mess.
Alex Gardner, for the record, I agree. He's owned the horseplay, and the question is whether what the grab actually constituted a wedgie. It's just all stupidity and unprofessional behavior, whether it was a wedgie or not. It's silly to be talking about it.
Martina, for the record, I would move that we remove dishonesty.
I would second that.
Do we want to talk about misconduct now and then vote together, or do we have to do the dishonesty first?
I'm good with whatever works for the committee.
It's open for discussion. I think so far we showed a pattern of going one or the other.
Okay.
But if misconduct is also up there, you might as well do it in one fell swoop. So if you have some concerns with the other one as well, I would recommend that you go ahead and discuss that as far as, adopting this, finding it is a moral fitness violation too.
And Scott and Ann, for the record, I do see misconduct. I think it's, everyone has said it is sophomoric behavior, but that's how we ended up here. There's a reason that you're not supposed to act like that, and I think so. From my perspective, this, especially inside of a facility where it's a really important job, and if you're horse playing too much, you're probably not doing your job very well. So I could. So I do agree that there is misconduct.
Alex Gardner, for the record, I agree.
Do we need to amend our motion then to get rid of dishonesty but keep misconduct?
I don't think we made a motion yet.
You didn't make a motion,
Yeah.
so now if somebody will make it, modifying it.
I did.
So we can withdraw our motion.
I'll withdraw my earlier motion, and I will restate a new motion by Mark Daniel for the record. I move that we remove dishonesty, however, we retain misconduct.
There, I would second that.
Right, we are voting on a motion to remove dishonesty, but keep misconduct as one witness violation. Chair Nani?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood? Motion passed.
Okay, so we're left with the violation of misconduct, and we need to call for a motion to take action or take no action. To take action, we're looking at 3-year minimum from
Alex Gardner, for the record, I move that we take no action. I think they can deal with this at the department.
Sheriff Brennan, second.
We are voting on a motion to take no action. Chair Nowning?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
You excused. Let's do it.
We have,
Oh, wait.
Kathy.
Say it.
Kathy, we have, his attorney is present.
Okay, so if we have only one more in person with Mr. Lanier online and his attorney here, before we take lunch with committee, be willing to listen. Yeah.
Okay.
But 3, tab 3.
We'll pre-tap review, so on division. Now tell me what the stuff. You need to write down my notes. Good job. What is it? Six.
I think there is, that I've read.
It's a good question. Something to ponder.
Yes.
Well, and I get, oh, that's enough. Did you try to, did you, what you? What did you do? Which one is it?
Those 3 tabs read.
Kevin, 3, tab 3.
Let's read that. No, you're right.
Okay, we're moving on to Kevin Lanier, who's appearing online.
Thank you. Good morning, Mr. Chair and committee members. The department opened a professional standards case to review the circumstances of Kevin Lanier's separation from the Jefferson County Sheriff's Office. Lanier initially terminated or requested to convert his termination to a separation agreement. Lanier's separation followed an internal investigation into his work performance and policy violations. The Jefferson County Sheriff's Office sustained multiple findings. In a review of the information provided by Jefferson County Sheriff's Office, the department found that Lanier created an inefficient operation of the Jefferson County Sheriff's Office when he failed to follow up on casework in a timely manner, and that Lanier threatened or harmed persons or property when he did not investigate referrals or investigate criminal conduct. The department submits its findings to the committee to affirm, modify, or negate. And Officer Lanier is here remotely to provide verbal mitigation and submitted written information for the committee to consider. Officer Lanier, if you're ready, you may begin with your statement to the committee.
Okay. Can everybody hear me okay? Okay, great. Thanks for your time today. The events that unfolded in August and September of 2022 really opened my eyes to taking care of myself. I made a lot of mistakes. I own those, especially handling casework, staying on top of it. You know, I've learned how to better do that. Some of the incidents that happened in September were affected by a concussion that I sustained after being rammed about 4 times, which I feel did affect my performance in the days after that. And this time off, I've spent a lot of time with counseling, learning where could I have done better, also remembering things a little more clearly, working on my cognitive function after my concussion. I don't want to put the blame on all that. I feel like that severely impacted my performance. You know, I want to say September 10th is when the ramming was, 2022. I strongly believe that I have learned an insurmountable experience through this, including, you know, in July of 2022, I was a witness with a officer-involved shooting. I recognize that I probably should have taken some more time off to work on my overall health. You know, I still have a passion for this career, and I look to have a long and meaningful career in law enforcement, helping the communities that I serve. You know, somebody once told me, smooth seas never made a good sailor. Well, it's been some rough seas, and I feel like I can definitely take what I've learned from this to provide better service, to be a more effective law enforcement officer. And again, I own my mistakes, my performance issues. I feel like I have taken steps to correct those in the future. As one of my letters that you received from my current chief at the Veterans Affairs, he doesn't have any concerns. And yeah, I own my mistakes. I came into this during COVID, and you know, there was room for improvement, and there's a need for improvement. I can see that. So again, I accept my responsibility. I'm very remorseful for it, and I've had many sleepless nights with some of this, wrapping my head around it, especially in the beginning. So thank you for your time. And again, I can't say it enough. I own my actions, my mistakes.
Thank you very much. Okay, so we need to either adopt the record, modify the record, delete the record.
I'll make a motion, Rob, for the record that we adopt the staff report.
Scotty Young, I'll second.
Voting on a motion to adopt the record, Chair Downey.
Aye.
Committee Member Barrett. Aye. Committee Member Brandenburg.
Aye.
Committee Member Sarek.
Aye.
Committee Member Cotting.
Aye.
Committee Member Daniel.
Aye.
Committee Member Fromm.
Aye.
Committee Member Gardner.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Wood. Aye. Motion passed.
Okay, we're going to have discussion on aggravating or mitigating factors in this case.
Rob Wood for the record. Reading through all of the allegations, which were all sustained, by the way, by the department, I look at every one of those as a performance issue. So that's a mitigating thing for me. Plus, his lack of tenure. We even brought that up during his testimony. He was a COVID recruit. So I present that as mitigating.
Okay, for the record, I agree with Member Wood completely.
Sorry, now, for the record, I agree as well. Every one of these came down to appears to be just not doing a super great job at the job. So I would make a motion to remove misconduct. I didn't see misconduct, I saw maybe not being very good sometimes.
I'll second that.
We need to clarify that if we remove misconduct, then we're.
But if that is the only one on the table, is misconduct,
So,
then you find no moral fitness by removing misconduct.
okay. So that's my motion, I find no moral fitness by removing misconduct.
We are voting on a
And Connie,
motion.
I think you have to second that.
And Connie seconds.
Okay, thank you.
We are voting on a motion to remove misconduct as a moral fitness violation and take no action. Chair Nally?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Sarek?
Aye.
Committee Member Cotting?
Aye.
Committee Member Daniel?
Aye.
Committee Member Fromm?
Aye.
Committee Member Gardner?
Aye.
Committee Member Throwen?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, thank you, Officer Lumiere.
Thank you. I'll follow up.
Thank you for your time, everybody.
Okay, I think we'll do lunch break.
Not a motion?
No, you know what's gonna happen if I hit hard? It's gonna break.
Yeah.